Welcome everybody to the Australian Earth Laws Alliance monthly webinar. I'm very delighted today to be able to introduce in a moment our guest speaker, Dr. Erin O'Donnell. But first I'd like to acknowledge country. My name is Michelle Maloney. I'm the National Convener of the Australian Earth Laws Alliance and I live in Brisbane. So I like to acknowledge country here in the Turrbal Yagara lands, acknowledge elders past, present and emerging. I like to acknowledge the remarkable governance system that First Peoples of Australia had and continue to have, which places the care of the earth and the care for each other at the centre of their society. I'd also like to acknowledge the ongoing legacy of colonisation, the impacts of colonisation on First Peoples, and the work that I do personally and professionally to be part of what I guess some of us call the decolonising project of this continent, where we can all support our First Nations colleagues in solidarity, but also indigenize our minds and think more deeply about our place on this continent. So I hope that you can all take a moment to think about where you are right now. And if you're in Australia, have a think about the plants and the animals that are your companions. And perhaps for many of you joining this call, your rivers and waterways, the very essence of our life, I suppose, the water of our life. I'd like to very briefly introduce the Australian Earth Laws Alliance. AELA, our website, which I normally call up, but I won't do it today. I'm busting to hear Erin's talk as well. But AELA's website is earthlaws.org.au. If you're joining us for the first time, please visit our website. You will find out a lot about our information and the work we do. In a nutshell, AELA is interested in shifting from human-centred to earth-centred governance systems. And our sort of mission in life is to play a role in supporting a shift for industrialised societies like non-Indigenous Australia to shift away from destructive patterns of behaviours and activities towards a much more progressive and harmonious way of being with the living world. So AELA runs projects across education, community-based projects, and a whole bunch of really remarkable partners and organisations that we work with. We play a strong role in creating viable alternatives, so how we can reimagine a different legal, economic and education system to support an earth-centred society. So we've got a bunch of other events coming up soon, and if I have time, I'll mention a few and give them a bit of a plug at the end of our webinar today. The other thing I'd like to mention is AELA was pivotal in auspicing the creation of the New Economy Network Australia, neweconomy.org.au. And it really is an expression of AELA's interest in shifting the economic system towards something that cares for planet and cares for people and away from current neoliberal market-based approach to organising ourselves. So both AELA and NINA and our sister organisation, Future Dreaming, welcome you today to this lovely webinar session. So without further ado, I would like to invite Erin O'Donnell to join us. I'll just switch the pinpoint of this webinar to put the profile on Erin. I hope she's okay with that. Erin O'Donnell, I met many years ago, a great admirer of her work. And I've watched Erin move from a PhD student examining remarkable, and at that stage, very unconsidered ideas around the rights of rivers or legal personhood for rivers into one of the world's leading authorities on this issue, because it's also coincided with an explosion of activity in this space globally. And I'm always grateful to Erin's latest articles and such, because she keeps me up to date with an analysis of what's going on in this really fascinating space. But I might hand over to you, Erin, and let you introduce yourself, any other details you'd like to share. And as I said, everyone, if you could please stay on mute. We'll have Erin speak with us for about 30 minutes and then I'll open it up for questions. So do feel free to type your questions in the chat. Thank you so much, and over to you, Erin.
Thank you, Michelle, and thank you everyone for having me here to speak with you today. My name is Dr. Erin O'Donnell. I am a research fellow at the Melbourne Law School at the University of Melbourne. I'm coming to you today from a little seaside town called Lorne, where I'm, surviving the Victorian lockdown. So I would like to pay my respects to the peoples of Eastern Maar and acknowledge that their sovereignty has never been ceded over lands and waters. I pay my respects to their elders, past, present and emerging, and I am thankful for the way that they have managed their country and cared for their country and continued to show us how it's done. So I'm now going to try and share my screen. So let's try and make sure that that happens smoothly. and then we can get into this conversation. Really looking forward, come on, there we go. Yeah, really looking forward to hearing your thoughts. So yeah, at any time, please drop a question into the chat, and yeah, I'll try and save some time for some conversation with you all at the end. So this presentation is really about thinking about what happens when a river becomes a person. How does it change the relationship between people and the river? And so I'm going to look at the number of different ways in which rivers have been recognised in law, and whether this is actually relating to the legal rights that they might actually need in order to survive. So as Michelle mentioned at the beginning, rivers around the world have become persons. And although rights of nature has been a movement that has long histories and long roots and has been in its modern form for decades and driving change in countries like Ecuador and other places, again, for a really long time. In 2017, that was really the year that things started to change for rivers. So we saw rivers around the world being recognised in different ways as persons. So the first river to make headlines was the Wanganui River in Aotearoa, New Zealand. And this was the result of a treaty dispute settlement between Māori and the New Zealand government. And it's important to remember that context, because we'll come back to that in a second when we think about what kind of arrangements have actually been set up in that case. The Rio Atrato in Colombia was a case that was actually decided in 2016, but 2017 was the year that this became public. This was a constitutional case, and it related to the human rights of the people that live along and love and depend on the river. And so the Constitutional Court said, well, actually the best way to protect those human beings' constitutional human rights is to recognise the rights of the river itself. So that's a fairly profound statement of the interdependence between people and place, and specifically people and rivers. Ganga and Yamuna rivers in India was another one that really put headlines around the world. These are two of the most iconic and beloved and sacred rivers in the world. They are the site of one of the largest religious festivals, the Kumbh Mela, which unfortunately this year was also a super spreader COVID event. So I would like to also acknowledge the horror and devastation that is currently unfolding in India. I think it's imperative when we think about these discussions to actually ground them in what is happening in place. And from that perspective, although Colombia has also seen a number of other cases to recognise rights of nature, they are also experiencing some very, very difficult times right now. So I send my thoughts and my solidarity to people in Colombia too. So those all happened in 2017, and there were other cases that year as well, particularly in India. This has been since followed by rivers and lakes in Australia, Bangladesh, Mexico, the USA, and other parts around the world. So this is a continually proliferating field in the recognition of rivers as persons, but they're all starting to do it in different ways. So to take us into that conversation, I'm going to ground this in a discussion quickly of the Yarra, the Birrarung River in Melbourne, which was Australia's first recognition of a river as a living entity. So the Birrarung, the Yarra River, is now recognised in law as a single living integrated entity. And so that's, again, it's an Australian first. It's a profound statement about the nature of country and the connection between country and people. This is also Victoria's first legislation that includes Woiwurrung language. So the traditional owners of the land were partners in the creation of this legislation. And so again, that is a long overdue first. I'm going to acknowledge that I am a member of the Birrarung Council. So I'm coming to this also as a bit of a situated knower. I'm engaged in the process of trying to figure out what it means to be the voice of the river, whilst also trying to connect it through my research into this global field of other examples. So the Birrarung Council has 11 members, 3 of whom are Wurundjeri Woiwurrung elders. We have an advice and advocacy role in the legislation. So we need to advise the Minister for Water, we need to advocate for the interests of the river. And we've been doing a lot of thinking about what does it mean to be the voice of the river? How do we speak for the river? And so this is a photo. It's a little bit old now because we haven't actually been able to gather all in person in the same place, but these are the members of the council. This is our attempt at a mission statement to say that we will champion the interests of the Yarra River, the Birrarung, as one living and integrated natural entity. And the way we will interpret those interests is through the 50-year community vision and the Wurundjeri Woiwurrung statement, which translates to the ancient spirit and law of the Yarra. And the reason we've done this is because we think it's not enough just to ground the interests of the river in Western ecology. We want to ground and understand the river in relationship with the human beings who live along and love the river. So those are the two documents, the two kind of foundational documents that we use to keep coming back to say, what does it mean when we are speaking for the river? Now, the interesting thing about the Birrarung Council, and again, keep it in mind for a slightly more complicated discussion we're about to get into, is that the river has no formal legal rights. So it's a living entity, but it doesn't necessarily rise to the status of a legal person. But this doesn't mean that we haven't seen any changes. And these new narratives that I'm seeing start to play out in the Birrarung Yarra context, I think are a profound indication of the transformative potential of recognising rivers in this way. So historically, and even still currently, we've had narratives that focus on the river in terms of an exploitative arrangement. What do we want from the river? How much can we take from the river? So the Yarra River still supplies 70% of Melbourne's drinking water. It's used as a stormwater drain. So it's used as a way to flush away excess water. It's still the source of sewage. So we tend to dump sewage into it. That's been an issue that has improved dramatically over the last 20 years, but it still happens in significant rainfall events. And of course, we rely on it for things like recreation and amenity, and people love to live along it and build on it. So that's the historical narrative. With the advent of the Yarra River Protection Act, Willipgin Birrarung Moron, what this started to shift towards is, what do we want for the river? And that was the community vision. This is a legislative instrument. It's an incredibly legitimate statement. It was a very expensive, very time-consuming process of engaging with all aspects of the Yarra River community to come up with a vision for what we wanted for the river in 50 years' time. So people started to think, hang on, what do we want for the river? And then when you recognise the river as a living entity, you start to say, well, how do we get there with the river? The river becomes a partner, a collaborator, an ally in its own management, in its own future, and we all start to work together. So even the absence of specific legal rights and powers, we're starting to see these new narratives, and that's influencing the way that people are thinking and planning and managing the river. So let's take that back up then into the global context. And when we look around the world, we can see that lots of these rivers are being given legal recognition in multiple different ways. And these differences matter because they define the kinds of legal rights and powers that the river will have, which also influences the narratives that emerge when the river receives those powers. So at the very top here, we have the idea of the legal person. This is something that most of us are familiar with in the Australian context. It's a common idea, particularly in common law countries like Australia, like the US, like Canada, like Aotearoa, New Zealand, where personhood is a kind of core idea of the law, even though it's not especially well defined. But what it essentially means is that you have a bundle of rights and responsibilities. So you have the right to go to court, to sue and be sued. You have the right to enter into and enforce contracts. You have the right to own property. Those are the kind of foundational legal rights that tend to be attached to a legal person. Human beings are legal persons. Corporations are probably the other best known form of legal person. The next one down is a subject of rights. So this is a slightly different form to a legal person, but still extremely legally powerful. The main difference comes in that because it is a subject of rights rather than a legal person, you need to specify what those rights are. And so you see this idea being used in civil law jurisdictions like Colombia. So it's a bit more flexible. The living person is something that we're starting to see not all that often. This is a little bit confusing when it comes to rivers because so far for the law, the only living person is a human person. So this sets up a few questions for what we actually mean, what kinds of rights we're bringing in when we talk about rivers being a living person. And finally, we have this concept of living being or entity. And so this is really just a statement from the law that the river, its landscape, its ecosystem, its country is alive. That's a profound shift, but it doesn't necessarily bring any new legal rights or powers or responsibilities. So when we look around the world, we can see that some of these kind of key examples of river persons are employing these ideas in different ways. So the Rio Trato is an entidad sujeto de derechos, and this is, in Spanish, is an entity that is the subject of rights. And so the court was able to enumerate the very specific rights: protection, conservation, maintenance, and restoration. Those are really important rights. The absence of a right to hold property is also an important omission. So that flexibility can also bring with it potential weaknesses. The Wanganui River brings together multiple ideas. It is an indivisible and living whole. So that's the living entity concept combined with a legal person with all the rights, powers, and duties and liabilities of a legal person. So bringing together both of those elements. And again, the Wanganui is an interesting one because the decision to make the river a legal person was primarily in order to avoid this question of ownership between Māori and the New Zealand government. New Zealand government didn't want to cede ownership to Māori. Māori said very clearly the river was taonga, it was theirs, they'd never ceded it. And so enabling the river to own itself was a circuit breaker in that decision. Gundjer and Yamuna rivers bring together all of the above. So they are legal persons, they are living entities, they are living persons, and that creates some confusions. So one of the things that happened in the Indian context is that as soon as the Yamuna received its status as a living person, with all of the rights of a living person, somebody filed a police report to claim that the Yamuna was murdered because it was too poisoned, too polluted to be considered alive any longer. So that's a really novel use of the living person idea and its application, but it does start to then raise questions. Well, what other human rights or human status in law are we bringing to rivers? And is that relevant? Is that meaningful for what rivers actually want? And of course, in Bangladesh, all rivers are legal persons and living entities combined. In the Australian context, we've talked about the Birrarung. It's one living and integrated natural entity. The Mudawara Fitzroy River is another river that is really worth paying attention to in this context. It's a living ancestral being with a right to life. Now, that has not yet received any recognition in settler state law, but that is the statement from the traditional owners of the Mudawara River in first law. So again, the emphasis on the living being with perhaps a specific right to life. Then the next question becomes, well, who are the guardians? Who actually speaks for these rivers, and how do you translate those rights and powers and different ways of personifying rivers into the law and into the processes of river management? So if we go back to the Rio Trato, this was a really interesting one because the court initially said, well, look, we'll just appoint a representative from the Ministry for Environment. That can be the river guardian. That was an approach very similar to the one that was used in Uttarakhand for the Gundjer and Yamuna rivers. Again, it was state government officials. The challenge with appointing state government officials is that they usually have a day job, so that's a bit of a problem. And frequently it was already their job to protect the river. So they may not have been doing it adequately, and giving them a kind of an extra status is probably unlikely to really shift that without much else. So in the Rio Trato, the community said, well, we don't think it's legitimate if we just have one person. We need representatives from each of the 7 villages, and we need a man and a woman from each of the 7 villages. So now they have 15 guardians in the Rio Trato. Wanganui has Te Putupua, which is the face of the river, the guardian. They are advised by Te Karawao, and they fit within the strategy group, Te Kopuka, and work with that strategy group for the management of the river. The Wanganui has 2 guardians, one appointed by the Wanganui iwi and one by New Zealand state government. I've mentioned the Uttarakhand situation. Probably the only thing worth saying there is that the guardians that were appointed by the court were so excited by their new responsibilities that they immediately appealed that decision to the Indian Supreme Court, and we've yet to see an outcome. So that the Gundjer and Yamuna rivers gained legal rights and then have sort of lost them again because the effect of that original decision has been stayed while we wait for the results of that appeal. In Bangladesh, the National River Protection Commission received the role of guardian. Again, this was an existing organisation. The court tried very hard to direct the executive arm of government to pass legislation to give this organisation the legal powers it needs to actually take action. But on appeal, the appellate division of the Supreme Court decided that the court can't tell the government what to do. So we're again in this limbo of waiting to see, will the Guardian actually get the powers it needs? Bureau and Council is the voice of the Yarra River, and the Muttawarra Fitzroy River Council, which again has no formal settler state recognition. Now, when we look at all of those rights and powers and guardianship responsibilities, how do they actually translate into the rights that rivers need? So rivers are defined by water. It's the presence of water, the presence of flowing water that makes something a river. So connecting those rights and powers into water law frameworks, making sure that rivers actually have the right to water, will be really central to giving force and effect to all of these new river persons and enabling them to continue to survive. But what we see when we look around the world is almost universally, no rivers have received rights to water as part of receiving legal or living person status. That's a major problem. That means that the rivers don't have the right to the resource that they actually require to remain as rivers. So yeah, it's a really big problem. It's important to think about the context. So again, if we look at the Wanganui River, for instance, Māori chose specifically to exclude water from that treaty dispute settlement. But they can come back and have another settlement discussion about water rights. And they did that very strategically. They looked at the writing on the wall and said, look, we're very unlikely to get what we think we're entitled to. So we'll just park that issue and we'll come back to it later. So again, a strategic decision in the Wanganui case. But when you start to look at this in a global context, the pattern emerges very clearly. And this is a big problem. We're starting to see rivers like the recent one in Canada, the Magpie River, that has a legal right to flow. That's a really important right, but unless it's connected in to the water law frameworks, it may not translate into a defensible right to water within the river. So the other way that these river guardians can actually play a role in protecting the interests of the river is by giving them a role in water management. Now, as you'd imagine, this is kind of complex, and I'm happy to go into any of these examples in more detail in the questions. But again, we see fairly consistently that the guardians play a very limited role in water management. In the Bureau and Council, for instance, we don't have a role in water management. The water rights for the environment on the Birrarung, the Yarra, are held by another entity, the Victorian Environmental Water Holder. And they only have rights over their specific rights to water. So the management of the water in the river sits with yet another organisation, and it's managed under a completely different set of legislation than that which governs the Yarra River protection process. So this disconnect is a real problem when it comes to these river guardians actually being able to give effect to their responsibilities to the river. And I think it raises really important questions about what we mean when we recognise rivers as legal persons. Are they actually being given the legal rights that they need? Are we ensuring that the rights that they have are connected and appropriately hooked into all of the other legal frameworks? Water law consistently across the world tends to operate in isolation from many other spheres of law. So that is also a problem. I think at the moment we're not really giving the rivers the rights and powers that they actually need to protect their own interests. So I'm going to finish up and then we can hopefully have a bit of time for questions. In summary, I think recognising rivers as legal or living persons or a combination is potentially transformative. We really can profoundly change the conversation. We can shift away from that extractive model where we try and take from the river and start to ask ourselves, what do we want for the river and how do we get there with the river? This also needs to be understood in terms of partnerships with traditional owners as well. So understanding what the river wants, the first people to ask or the first people to answer that need to be the people who've been understanding that and interpreting it for tens of thousands of years. But ultimately, without rights to water and without a role in water management, we really risk still selling rivers short. So I'm going to stop there. I'm going to stop sharing.
Thank you, Erin. You're well within your time, so we've got some nice time for.
I am too.
Yes, thank you. We've got a couple of questions, but before we go to them, I'd like to ask a couple of questions just to frame some of the river rights developments inside the bigger picture around rights of nature and other legal personhood developments for other entities. So for those who may be familiar with other activities around the world around rights of nature, the way I often describe it is think of rights of nature across a jurisdiction as a blanket law, a law that says everything in this jurisdiction has the right to exist, thrive, and evolve. And this was some of the earliest forms of rights of nature or changing the legal status of nature laws that we saw. We know that Ecuador was the first country to have a Western style or modern constitution. 2008 said all of nature has rights. But it also in the same breath gave a whole bunch of extra rights to mining. So anyway, I'm not judging any of that at the moment, but what I want to ask you about, Erin, is the differences in these new legal status of rivers, which you've outlined, are all inside what I would call the second branch of changing the legal status of nature, which is focused on an ecosystem. What's your take on the jurisdictions like Ecuador? We know Bolivia's done nothing much at all, but across the US, there are dozens and dozens of little communities who've said that their community has the rights of nature. You know, all of the living world has a right. So it's not just one ecosystem, it's across a jurisdiction. And there are other places where the rights of nature across a jurisdiction have emerged, although they're not in practice yet, like Uganda. So on the one hand, we have a place like Ecuador saying all rivers have a right to exist, thrive, and evolve. And under that framework, anyone can speak for a river. There are no such thing as guardians because anyone, it's open standing, anyone can speak for the river. Can you talk a bit about how that's different to, say, the Wanganui River or the Bururung Council's role? Because to me, there's all these fascinating and different ways of doing things. So, yeah.
Yeah, I think that's a really good place to start. So I think it really comes down to what you're trying to achieve with the legal changes and the rights of nature. So nature exists holistically. We're all in nature all the time. I'm standing here in my living room and I'm within nature. Nature is everything around me. So in some ways, I think the concept of country that I learned about from Aboriginal people as an all-encompassing thing that we are part of is a really important starting point. So in that sense, recognizing nature everywhere as having the right to exist and flourish and thrive and evolve, that's compelling and that's really meaningful. But when you look at at what happens next, that's when potentially things start to go a little bit awry. So if nature everywhere has rights and anyone can speak for nature, is it anyone's specific responsibility to do that? So that's the first question, is who is going to stand up and how are they going to fund that? Running a court case to protect nature's rights is incredibly expensive. So one of the first cases we saw in Ecuador, which protected the rights of the Rio Vilcabamba, a river that was being impacted by road construction, was run by citizens, it was supported by NGOs, but then they needed to go back to court to get enforcement orders. And that created additional financial imposts and really slowed all of that process down. So without having organisations, without having nominated guardians, there is a real risk that the rivers don't actually have the backup they need, or that nature doesn't have the backup that it needs to actually stand up for its own rights. So I think, the first question is, what are you trying to achieve? I think when we look at the different ways that nature can receive rights, that again starts to frame what we're seeking to rely on it for. So if we're looking at legal rights and we're looking at legal standing and the ability to go to court, then we need to couple that with force and effect. And that means organisational arrangements and funding and all of the things that you need to actually be able to give effect to those rights. I think there's also a question, I think, for non-Indigenous people around how we actually identify and understand what nature is in context. And so for me, I think that's been one of the really interesting things about seeing rivers receive rights, is that people can understand what a river is. And I know that the science of hydrology and hydrogeology and understanding the surface water and groundwater interactions, it's very complicated to actually draw the line around, this is the river catchment. But actually, we can visualize what it means, and we can start to think about, okay, I can get my head around what rights might make sense for this river and what interests this river might have and what my relationship with this river is. So in terms of some of the transformative shifts in the way that we think and that we relate to nature, then identifying specific natural entities, I think, is a really, really compelling pathway to changing and resetting the human relationship with nature. I think the only other point I'd probably end on is that when it's really broadly defined, it can also be a potential weapon that can be misused. So in Ecuador, for instance, there have been quite a lot of cases that have relied on, or that have called on, the rights of nature as part of establishing standing or of progressing a court case. Not all of those cases were really focused on protecting the rights and interests of nature. They were using that as a way of prosecuting sometimes another completely different agenda. So I think we're learning a lot as countries experiment with different ways. I think one of the challenges with the local ordinances, so we've seen that proliferation across the USA particularly, is that they still focus on the legal system, but then they always fall down. So when you change a local law and it's inconsistent with a state law or a federal law, then it's usually invalid to the extent of that inconsistency. And so on the one hand, it's really powerful to keep trying and to keep putting the interests of nature into those conversations. But on the other hand, I think we also need to look at, well, what happens when rights of nature are actually held to be invalid? And then you've got potentially a fractured community. So Lake Erie, I think, is a really good example of a recent decision to recognise the rights of the lake. Farmers then felt immediately threatened by that because they thought they would be on the hook for any potential contributions to pollution in the lake. And then they immediately sued to challenge the validity of that. And they won. And then the lake is left without rights. The community is divided. Kind of what happens next, I think, is the question for those circumstances.
Thanks, Erin. And I think conflict in the space around trying to protect the living world from excessive human destruction, I think conflict is inevitable. It's the processes we use to get back up and keep talking to each other, that move forward, that certainly impressed me. I might come back before we finish today. We were working with a couple of folks in the Blue Mountains, and the Blue Mountains Council has decided to incorporate rights of nature into its planning and policies, which is a really interesting take on how to explore what this looks like. And in some of the briefing papers that I did for them through the AELA frame, it was all about, well, actually, you're already surrounded by a World Heritage Park. What difference would this mean? And it's really about rethinking the economics and the value that we place on things as well. So I'm very glad they didn't go for a law because of the reason you just said with Lake Erie. And a lot of the American approach is make a law, then work it out. Whereas I think us Aussies are a bit more careful and slow moving. Like, number one, we're working in a colonial environment. What do the mobs say? And number two, how do we all work together? Which, as you know, Erin and others, I work with Mary Graham, and we're actually working on a book about that. If we look at the relationist ethos and all these other things, how do we work together into the future? And how do we do this in a way that doesn't feel like endless conflict and, I guess, compromise over caring for the living world? So anyway, what I was going to do is I might come back to the Blue Mountain stuff and throw some questions at you about this broader, weird and interesting way of trying to integrate ecocentrism into their planning, which I think is really cool. And it opens up a whole space for community dialogue, which I think is what has to happen. But we've got a couple of great questions here, so I'll just read them out for starters. So Miles has asked two questions, and he's put, how does this compare to corporate personhood in terms of rights, access to justice, etc.? So I think he's asking, how does river rights compare to corporate personhood? And then he's asked, are you willing to comment on Jacinda Ardern's recent negotiations around water runoff management in New Zealand? I don't know if you want to go that specific or if you just want to start with the first question.
Happy to start with the first question. So I think the comparison with corporate personhood is a really, really useful place to start as well when we start thinking about what is the appropriate model in law for recognising the status of rivers. And so if we think about the origins of corporate personhood, and the origins go back many hundreds of years, the modern version of the corporation really started to emerge when people wanted to separate risk from reward. They wanted, as shareholders, to be able to invest in the company and take the profits, but they wanted to create a legal person who would be bearing all of the risks. So this would be a new identity. So they would be shielded from the risks and liabilities that would attach to that corporate entity. So that's a really uncomfortable history when we think about the application of that concept to rivers. Rivers have no interest in separating risks and reward. When we recognise rivers as legal persons and as living persons, we do not do so because we want to separate ourselves from rivers. And the legal person concept has come under attack from Indigenous peoples in multiple parts of the world because it appears to fracture the relationship between people and country by creating this separate identity for country. So that's, yeah, these are real problems. I think the legal person is a translation of a bigger idea in Western law, in Euro-Western law particularly. So it was the available legal tool. I think it's certainly not an ideal legal tool. It's what you start with, and then you try and figure out what are you actually trying to do? How do you bring in the rights and interests that are meaningful, the powers that you actually need to give rivers rights and personhood. But fundamentally, we're probably more about the transformative outcomes rather than potentially going to court, although that could well be an important necessity as well. I think there's a great video that's available on BBC Reel where Gerard Elbert from the Wanganui iwi talks about the importance of that legislation in generational terms. So he sees it as leading to generational change. And I think that's really what we're talking about here when we think about personification of rivers in law, is that we're setting up for these long-term shifts in the way that we think and the way that we understand the world around us and the way that we manage ourselves and our impacts on the world around us. So Michelle's initial words about earth-centered governance, I think that's where this conversation needs to be taking us. And if we get bogged down in an adversarial conversation or in a fractured relationship discussion, then that can take us away from that longer-term transformative outcome. So let me just try and scroll up and find your second question there. So water runoff management in New Zealand. I am not a water quality expert. What I have seen is that the standards that the government's looking to put in place are probably not adequate. Again, I'm kind of catching that in generalities because I'm not an expert on that, but I have read material from people who are experts. I think water quality is emerging as the major issue in New Zealand, not only for the health of rivers, but also for the health of people. There was a study just recently that looked at the impact of nitrates on preterm delivery and the health of babies. So this is a really, really important issue in New Zealand. It does bring into all of those issues that Michelle again was flagging around the conflict between I guess the development aspiration of human beings and our need to continue living in the world around us. If we destroy country, then we've destroyed our own place in it as well. So I think New Zealand, the conversations in New Zealand, I'm watching with great interest. One of the things I was most interested in is Te Mana o Te Wai, the new policy on water. I think that opens up some really interesting conversations, and it's starting to shape the way that the law is understood, even though it is not a legal document in and of itself. So I think, there's a number of different processes happening in New Zealand that, are going in both good and not so good directions.
Thank you, Erin. I'm just going to work my way through some of these questions. I actually grouped them all in a separate document, but I've popped them back into the chat so you can see them if you need them. But I'll go through them for you. So Teresa has asked a question, and it's actually similar to another one further below, but Teresa has asked, presumably a great deal of negotiating would need to take place if a river flows through many countries and borders. And I guess this relates to, so far, a lot of the rivers we've seen getting their own rights are in one national, at least, jurisdiction, if not across provinces. But Did you want to comment on that, Erin?
Yeah, look, that is a really good point, and that was one of the reasons why the Gunja and Yamuna case was appealed as well. So the original decision was from a state high court in the Tarakan. Tarakan sits up the very top of the Gunja River, and the Gunja and the Yamuna together flow through multiple states in India and then become the Padma River and flow out through Bangladesh. So recognising the river as a living person and a legal person in a united sense, and the court did not specify this was only the river in Uttarakhand, raises really big jurisdictional questions about the abilities, particularly of the Uttarakhand state government guardians, to adequately act as guardians for a river that extends not only out of their state borders, but also out of the nation borders as well. So that is certainly a big issue. And it's one that is also going to come into play with, I don't know if you guys saw in the ABC, there was a really nicely done but heartbreaking story about the development on the Yalang Sangpo River, which flows through China and then India and then Bangladesh. Yeah, so they're looking at producing a major, like world's largest hydropower dam at this incredibly remote site on the river where it does this kind of U-bend and loses a massive amount of height as it curves around mountains. All of the rivers in Bangladesh are now legal persons and living entities, all of them. So when that river reaches the Bangladesh border, it gains significant new legal rights and powers. Can you recognise the personhood of something when you're only recognising part of the something as a person? I think this is the other really important question when we think about natural entities like rivers, is that they demand us, they require us to see the holistic entity, all of the river and its lands and its interactions from the mountains to the sea. And Wanganui is wonderful in this because it actually talks about both the physical and the metaphysical elements. So it brings in the spiritual and relationship elements as well. So if we see the rivers as single beings, the fact that they cross borders is kind of irrelevant to their personality. And so potentially the recognition of the rivers as legal persons and living beings in Bangladesh could raise issues for the development of that Chinese hydropower scheme. Now, when you start getting into international law, the whole other kettle of fish, and then the relative power between nations becomes important as well. So having a new player in there in terms of the river and its rights, I think creates a space for some interesting conversations. But yeah, Bangladesh has been living at basically at the bottom of river systems for a long time, and they really struggle to get their rights and interests respected by their upstream neighbours, who are also pursuing their own kind of human rights and development agendas. So yeah, watch this space. I think that'll be an interesting conversation. It'll be interesting to see whether any international NGOs pick that up and whether the rights of those rivers do start to have impacts beyond the borders of Bangladesh.
Thank you very much, Erin. And in fact, perhaps everyone can have a think about what it's going to look like when somebody starts arguing for the Barker River or the Murray-Darling system to have better rights, which a lot of us are already saying, you know, what we need is Aboriginal people to sit down and talk about how they ran the river and then convert that into a more modern understanding of how to share nicely with others. And we already see the states' arguments in Australia across shared resources. I mean, I don't think you could get any more verbal violence in the international scene than what we see between our state leaders anyway. So, and then it actually raises all the other issues about, well, how do you separate the river from everything else that it's connected to, which actually links to the next question. Someone's asked, how would you classify, you know, the, I took the question down because I was answering somebody else. Too many things going on. Floodplain harvesting. You know, you'd have to argue that floodplain harvesting is against the rights of the river or the interests of the river, let alone the interests of all life. But do you have any thoughts on that, Erin, in terms of the role of floodplains? Because what we've seen across New South Wales and Victoria is criminal in this regard.
Yeah, one of the most devastating things I think you can see is aerial photos of the Murray-Darling Basin that show trees that are alive literally along the very edges of the rivers, where rivers have been able to remain flowing. And in parts of the Murray-Darling, that's because they've, you know, had water pushed down them. So they're being treated like pipes as well. Floodplains have lost out dramatically, particularly over the last 20 years, but really over the last century since we started putting in large dams and weirs along the Murray and its tributaries. So floodplains are crucially important. You can't separate a floodplain from the river. It makes absolutely no sense. The river nutrients, the river communities depend on floodplains, and floodplains depend on rivers. The communities that live along those floodplains depend on floods of certain frequency and duration and extent in order to survive. Climate change is threatening all of that. So that's kind of problem number one. Problem number two is that floods don't have to be gigantic in order to play a massively important role in floodplain health and management. What floodplain harvesting threatens is those small to medium floods, because those are the ones that can be most kind of, you can capture almost all of the small to medium flood in large offstream dams, which are what we've seen proliferate in northern New South Wales. So again, that's nothing new. Scientists have been saying this for a very long time. I think it was Fran Sheldon who wrote a report last year or the year before that said that upstream extraction pushed the river system into drought years ahead of what it should have done in the last drought in New South Wales. So we know that it's a massive problem. We know that it's got worse since 2012. We know that. It poses massive risks to the health of river systems. I think the challenge with floodplain harvesting is not that you should never, ever do it, but that the only way you can do it is if you have extremely tight regulation, and we simply don't have that. So we're not effectively metering how much water people are actually capturing in their dams. We're not thinking about controlling or the compliance and enforcement arrangements that are needed to make sure that people are only capturing water when they're allowed to. These are, this stuff is happening a long way away from really where most of us live. So yeah, I think I have personally very little faith in the floodplain harvesting arrangements that are being currently proposed by New South Wales. They have absolutely taken no account of the rights and interests of traditional owners, most of whom have zero water rights. So yeah, we're kind of screwing the river, screwing the floodplain, and continuing to deny traditional owners' rights and interests. It's a bad outcome.
And I've given a little plug in the comments, a link to the report done by the Citizens Inquiry into the health of the Darling Barker River, which myself and many others were involved in. And it really does give you the voices of the people along the river, explaining the problems and explaining what they think are the solutions. And I have to admit, I never realized floodplain harvesting was so rife and so evil and disgusting until we did that particular project. So thank you very much, Erin. There's a great question here from Sue. When I was in Bangladesh in 2011, and as I understand it, Monsanto had replaced the rice that people had been growing forever with GMO rice that ultimately killed off a lot of the river's ecosystems. So would giving the river rights have protected that?
That's a really interesting question.
It is.
Yeah, so I think this gets into the force and effect stuff as well. So I think as a first order question, would the river have obviously an interest in maintaining its ecosystems? Would it have rights to do that as if it's recognised as a legal person? And I think the short answer is going to be yes. In almost every case, the river will be recognised as a river, which incorporates its ecosystems. So it would have the right to defend itself against those kinds of impacts. Whether that defence would actually amount to anything, I think, is the next question. And to make that happen, we need to start thinking about force and effect. So who would be running that case? How would we be funding it? What kind of enforcement orders would the court actually be able to make to prevent those kinds of actions? Now, we have just seen, in a completely unrelated space, the court in the Netherlands tell Shell that actually they need to cut their carbon emissions by 45% by 2030. Shell has always argued that it can't do this without actually undermining its own business model, and that's held up in the past. But we're seeing, I think, an increasing willingness of courts to look beyond that. So I think in that instance, I think that would be a really interesting case, because again, in the Bangladesh context, the reason why all the rivers received rights is because Bangladesh judges were desperate to find new ways of protecting rivers. So I've heard the particular judge in that case speak about it, and he speaks very movingly of rivers and lakes that he has known since he was a child and watching them decline and disappear. So Bangladesh has actually lost a lot of its rivers. They've declined massively. So this was him trying to reach within the law, to find anything within the law that he could to stem the tide of that destruction. So in a Western context, in the Australian context, in the US, in Aotearoa, New Zealand, we would call that an activist judge. And that's usually a pejorative term, somebody who is stepping outside the bounds of the law and pursuing their own agenda from their seat in the judiciary. I think what we are seeing is judges, like the rest of us, becoming desperate, trying to find something that will give them the chance to change the trajectory for life on this planet. So I think we really need to re-examine whether or not activist judge should ever be pejorative term. Obviously, we need to think about what the rule of law is and how that's applied. But yeah, we are in an increasingly desperate situation, and finding innovative ways to change that is really important.
Thanks, Erin. And I will add, in my usual chipper fashion, that there's some pretty cool examples of other Indigenous groups actually declaring the rights of their local plants and seeds and things. The Manuman rice, which was the White Earth group of the Ojibwe tribe in North America, it's in the US part of North America, actually declared the rights of Manuman rice. And it was particularly to challenge the invasion of GMO. So that's interesting. We've got a little article about that on the AELA website. And also, if you're interested in protecting seeds and life from the plants generally, Vandana Shiva's work, The Law of the Seed, her challenge to GMO, and challenging corporate and intellectual property concepts from the Western world, taking over and controlling plant life. Yeah, really, really, really important and interesting stuff. And I think, as Erin said before, a lot of these concepts are really in their early days. I like to think that what we're seeing across all the variations of legal personhood and legal subject, or subject rights, recognizing an entity as a living being, it's all the Western legal system fighting back with itself now. It's like the Western law, which traditionally sees nature as property, is now being pushed by its people and other peoples, obviously, to change the way it sees nature, to change what it allows to happen. And I've often said that I think the clunky efforts we're all making right now will appear in 10, 20 years' time, a bit like the early efforts to fly. They're going to be seen to be a bit clunky and a bit awkward when in fact, what we need to see is all of these efforts pushing back at Western industrialized societies to grow themselves an earth-centered ethic, the way other cultures manage to do. So that's why I find it very, very interesting, and all of it's good. Anything that's starting to push at the edges of the concrete of Western systems of treating nature dismally, probably a good thing. We're starting to wrap up, but there's a couple of big picture general questions which we might not have time for.
Shall I go with the question about the floodplains? And
I actually sort of asked that one, but what I do have, if you want to say more about it, you can. Otherwise, I've got a question from Margot in relation to South Africa, but I'm trying to find the actual specific nature of the question because there's a comment at the beginning. Hang on. Too many wobbly bits in my... Oh, has any country adopted an approach where they give specific rights of nature to legally recognized strategic water source areas?
So yeah, I think that's a really interesting conversation, because then we start to get into this nexus between rights of nature and water law and water management. So as Michelle kind of indicated at the start of this session, my way into this conversation has come through a long history of working in water law and policy. So my PhD was looking at environmental water managers, so people who hold rights to water on behalf of the environment in different contexts, and whether this was a sort of proxy or de facto way of extending rights to those rivers themselves. And this research was happening in advance of 2017 when all the rivers started to get rights. So South Africa is a really interesting example because the environmental water reserve there is a legal right to water. And it's up there with, so I think there's an ecological water reserve in South Africa. It's up there with the sort of human water rights as the two foundational, most important rights to water in the water management system. So we're starting to see these rights to water head in the direction of having nature or the environment starting to hold rights of its own through the fact that those rights exist. The environment itself is seen as the holder of those rights in various ways. It's usually not a really direct relationship, but in some instances, there are legal persons who are created in order, like, just to hold those rights and to act on behalf of those rivers. So the Victorian Environmental Water Holder is one example. In Australia, the Commonwealth Environmental Water Holder. There are a bunch of government and non-government entities in the US that do the same kind of thing. There is a recent example in Mexico where ecological reserves have been recognised with kind of ecological water rights. So again, people are starting to try and draw these connections. Trying to think off the top of my head, I don't think there's anywhere that has actually made that explicit. And so that's a challenge. We still need to try and actually figure out how do we get things together and make these connections in a meaningful way. And that's really one of the problems I'm trying to draw to people's attention by saying, look, none of these rivers that we've recognised as legal persons or living beings have rights to water. We need to connect those different sources of law and those different ways of managing and thinking about rivers to give these things force and effect. I think the other way into that conversation is as well to think about what you're calling strategic water source areas, and it's that place-based way of thinking about water and water management. So again, Euro-Western law tends to lean in the direction of universalizing. So we abstract. We say, let's create a right to water that can then be applied in lots of different contexts. That's often separated from land, so we can buy and sell it in a market like a commodity. And actually, what we need is place-based legislation that says the most important foundational unit here is place and the relationship between people and place. And then we can see the connections beyond that. And that, I think, that's the way into this conversation. I think that's the opportunity created by the Yarra River Protection Act. It's an unrealised opportunity as yet, but I'm hopeful that people will continue to start thinking about it in terms of, okay, well, if we think about planning, maybe we can also think about water management and start uniting those as well.
Wonderful. That's a great comments there, Erin. The place-based approach. I think more and more of our Western legal system is starting to listen to what people are saying instead of the top-down standardised laws scattered across a place and everyone's struggling to fit their particular issue in. Let's make that particular place sacred anyway and work out how we care for it. So look, what we might do now is just start to wrap up. I'm really grateful to such a wonderful audience and some really thought-provoking questions. I'm going to just give a small plug, no, not for my desktop and not for my calendar. I had that ready. I would like to do an official thank you to Erin for her generosity, sharing her wonderful expertise. And please do Google her and look up her articles. And I just wanted to mention to anyone who's not familiar with AELA, our website has a whole range of portals into wonderful worlds. And this one, the Australian Earth Laws Centre, is a place where you can go in and find out about rights of nature, legal personhood, ecocide, ecological law, first laws, although they're more in here, lots of other cool things. And we've got a range of really interesting webinars coming up in the future. Our next webinar is on the 1st of July with Justice Preston, the Chief Judge of the Land and Environment Court of New South Wales, talking about climate conscious lawyering. And don't be frightened off if you're not a lawyer. What he's talking about is the kind of the deep obligation that professionals should be having to this greater care and thinking about things beyond us. And if you're interested in what the Blue Mountains folks are up to, we did a press release when they first made their decision. To me, this is like the Birrarung Council, one of the more exciting spaces in Australia at the moment. There's so much doom and gloom with all the things that are going on and extracting and wrecked. But this is an opportunity for a community to actually say, well, hang on, what does any of this look like for us? And I personally see rights of nature as only a spearhead concept, to open up the conversation that right now our system of law and economics and politics treats nature like property. And how do we move beyond that into something new, something appropriate to place, and something really suitable for our colonial space, where we're trying to open up the space for Indigenous people to be back in charge of their own lands and supporting each other in that way. So there's lots of other good things coming up in the AELA space. Please check out our website. I really hate giving that kind of live commercial, but I have to plug AELA, otherwise I forget. But look, let's all give Erin a suitably daggy air clap. Yay! Or you can press the little button that shows the yellow clapping hands. Either way, it's all good. And we are really grateful to you, Erin. There's been a lot of interest in this, and the recording from our chat will be available on the YouTube channel and website probably next week if we do our jobs well. So thank you so much, Erin.
Thank you so much for having me. And yeah, anybody who wants to get in touch, please reach out. I'm on Twitter fairly often, especially in lockdown. Otherwise, yeah, really happy to continue the conversation.
Yeah. Thanks so much, Erin. And hope to see you all again somewhere soon. So take care, everybody, and take care, everyone in Victoria. We're thinking of you. Can be any of us next. So take care. Bye.